To make a contract, follow these general steps. 1. Identify the parties involved. Start by identifying all parties involved in the contract, including their full names, addresses, and contact information. 2. Define the terms and conditions. Clearly define the terms and conditions of the agreement, including what each party is agreeing to do, the timeline for the agreement, and any specific conditions that must be met for the contract to be considered fulfilled. 3. Specify any limitations, if there are any limitations or restrictions on the contract, such as a specific geographic area or a time frame, make sure to clearly specify them. 4. Include any legal requirements. Depending on the nature of the contract, there may be legal requirements that need to be included. For example, contracts involving the sale of goods may need to include a section on warranties and liabilities. 5. Determine the payment structure. If the contract involves payment or compensation of any kind, determine the payment structure, including the amount and frequency of payments. 6. Review and finalize the contract. Once the terms have been defined, review the contract carefully to make sure it is complete and accurate. After reviewing, have all parties signed the contract to finalize it. It's important to note that depending on the complexity and nature of the contract, it may be advisable to seek the advice of a legal professional. Additionally, different countries and states may have different laws and requirements for creating a legally binding contract, so it's important to research and follow the specific regulations that apply to your situation. If you want to know more about law, please subscribe to the channel. Creating a legally binding contract can be a complex process, and it's important to ensure that all parties involved understand the terms and conditions before signing the agreement. Here's a step-by-step guide to help you create a contract. 1. Identify the parties involved. Start by clearly identifying all parties involved in the contract, including their full names, addresses, and contact information. This will help to ensure that everyone is aware of who is involved in the agreement and can be held accountable. 2. Define the purpose of the contract. Clearly define the purpose of the contract, including what each party is agreeing to do and any specific conditions that must be met for the contract to be considered fulfilled. This should include a detailed description of the goods or services that will be provided, the timeline for the agreement, and any other requirements that are relevant to the contract. 3. Specify any limitations or restrictions. If there are any limitations or restrictions on the contract, such as a specific geographic area or a time frame, make sure to clearly specify them. This will help to ensure that everyone understands the scope of the agreement and can comply with any restrictions or limitations that are in place. 4. Include any legal requirements. Depending on the nature of the contract, there may be legal requirements that need to be included. For example, contracts involving the sale of goods may need to include a section on warranties and liabilities, while contracts for services may need to specify the scope of the work that will be performed and the terms of payment. Five. Determine the payment structure. If the contract involves payment or compensation of any kind, determine the payment structure, including the amount and frequency of payments. This should also include any penalties or fees that may be incurred if payments are late or if there are any issues with the delivery of goods or services. 6. Review and finalize the contract. Once all of the terms have been defined, it's important to review the contract carefully to ensure that it is complete and accurate. This may involve reviewing the contract with legal counsel or other advisors to ensure that it is legally binding and enforceable. Once the contract has been reviewed and finalized, all parties should sign the contract to indicate their agreement to the terms and conditions. It's important to note that creating a contract can be a complex process, and it's important to ensure that all parties involved have a clear understanding of the terms and conditions before signing the agreement. Additionally, different countries and states may have different laws and requirements for creating a legally binding contract, so it's important to research and follow the specific regulations that apply to your situation. If you have any questions or concerns about creating a contract, it may be advisable to seek the advice of a legal professional. In order to create a legally binding agreement, a contract must include certain key elements. These elements are: 1. Offer. An offer is a proposal made by one party to another, indicating that they are willing to enter into an agreement. The offer must be clear and specific, and it must be communicated to the other party. 2. Acceptance. Acceptance is the agreement by the other party to the terms of the offer. Acceptance must be unambiguous, and it must be communicated back to the offering party. 3. Consideration. Consideration is something of value that is exchanged between the parties as part of the agreement. This could be money, goods, services, or anything else of value. 4. Intention to create legal relations. Both parties must intend for the agreement to be legally binding. This means that the agreement must not be made in jest, and both parties must understand that they are entering into a legally binding agreement. 5. Capacity. Both parties must have the legal capacity to enter into the agreement. This means that they must be of legal age and of sound mind. 6. Consent. Consent is the agreement of both parties to the terms of the contract without any undue influence, coercion, or misrepresentation. 7. Legality. The contract must be legal and not contrary to public policy. This means that the agreement cannot involve illegal activities or activities that are against the law. 8. Certainty. The terms of the contract must be clear and certain. This means that the agreement must be specific and not vague or ambiguous. 9. Formalities. In some cases, the contract may need to meet certain formalities, such as being in writing or signed by both parties. It's important to note that the specific elements of a contract may vary depending on the jurisdiction or the type of contract being created. Additionally, some contracts may include additional terms or provisions that are specific to the situation at hand. If you have any questions or concerns about creating a contract, it may be advisable to seek the advice of a legal professional. In Mexico, there are several types of contracts that are recognized under Mexican law. Some of the most common types of contracts in Mexico include: 1. Sale and purchase contract. This type of contract is used to transfer ownership of property or goods from one party to another in exchange for payment. This type of contract is commonly used in business transactions and real estate deals. 2. Service contract. A service contract is an agreement between two parties where one party agrees to provide a service to the other party. This type of contract is often used in the service industry, such as for consulting services, marketing services, or construction services. 3. Lease contract. A lease contract is an agreement between a landlord and a tenant where the tenant is given the right to use a property or asset for a specific period of time in exchange for payment. This type of contract is commonly used in real estate transactions, such as renting an apartment or commercial space. 4. Employment contract. An employment contract is an agreement between an employer and an employee that outlines the terms of their employment, such as salary, job duties, and benefits. This type of contract is often used to ensure that both parties are clear on the terms and conditions of the employment relationship. 5. Loan contract. A loan contract is an agreement between a lender and a borrower where the borrower agrees to repay a loan with interest over a specific period of time. This type of contract is commonly used for personal or business loans. These are just a few examples of the types of contracts that exist in Mexico. Other types of contracts include partnership agreements, franchise agreements, and non-disclosure agreements. It's important to consult with a legal professional to determine the specific requirements and regulations that apply to the type of contract you need to create. Contracts can contain a wide range of clauses, depending on the specific agreement and the needs of the parties involved. Here are some common types of clauses that are often found in contracts. 1. Confidentiality clause. This clause requires one or both parties to keep certain information confidential and not disclose it to third parties. 2. Force majeure clause. This clause outlines how the parties should proceed in the event of unforeseen circumstances beyond their control, such as a natural disaster or political unrest. 3. Governing law and jurisdiction clause. This clause specifies which country's laws will govern the contract and which jurisdiction will have the authority to interpret and enforce the contract. 4. Indemnification clause. This clause specifies that one party will hold harmless and defend the other party against any claims, damages, or losses that may arise from the contract. 5. Non-compete clause. This clause prohibits one party from engaging in certain activities that compete with the other party's business. 6. Termination clause. This clause outlines the circumstances under which the contract may be terminated, and the process that should be followed if termination occurs. 7. Warranties and representations clause. This clause provides assurances that one party is making to the other party about certain facts or circumstances relevant to the contract. 8. Assignment and delegation clause. This clause outlines whether and how the parties may assign or delegate their rights and obligations under the contract to a third party. 9. Payment and invoicing clause. This clause specifies the payment terms and conditions, such as the amount, currency, and due date of payment. 10. Intellectual property clause. This clause sets out how any intellectual property rights related to the contract will be owned and used by the parties. These are just a few examples of the many types of clauses that can be included in a contract. It's important to carefully review the terms and conditions of a contract before signing it and to seek legal advice if necessary. Determining the type of contract that is needed depends on the specific situation and the needs of the parties involved. Here are some factors to consider when deciding what type of contract is appropriate. 1. Purpose. What is the purpose of the contract? Is it for the sale of goods or services, employment, lease or rental of property, or another purpose? 2. Parties. Who are the parties to the contract? Are they businesses, individuals, or a combination of both? 3. Obligations. What obligations are the parties agreeing to in the contract? For example, are they agreeing to pay money, provide services, or deliver goods? 4. Risks. What risks are associated with the contract? For example, are there risks related to the delivery of goods or services, or risks related to the performance of obligations? 5. Legal requirements. What are the legal requirements that must be met for the contract to be enforceable? For example, are there specific formalities or legal requirements that must be met for the contract to be valid? 6. Local regulations. Are there any specific local regulations or industry standards that must be followed when creating the contract? For example, certain industries may require specific terms or clauses to be included in the contract. 7. Expert advice. In some cases, it may be necessary to seek advice from a legal professional or other expert to determine what type of contract is needed for a specific situation. By considering these factors and seeking expert advice if necessary, you can determine what type of contract is appropriate for your specific situation. It's important to carefully review the terms and conditions of the contract before signing it to ensure that all parties understand and agree to the terms of the agreement. A contract is a legally binding agreement between two or more parties.